Hello, hello, everybody. Hey guys, looks like we're just getting some more people in. We're just going to wait a minute or so to get everybody in and ready for this awesome session. Awesome, guys. We're going to give it about 30 more seconds just to get a few last people in. I know we just marked 2:30, so we'll let people slide if they're a minute late. Awesome. We'll go ahead and start. For people that are just now getting in, welcome, of course, to Texas Restaurant Association Marketplace 2020 online virtually. We're super excited. My name is Ariel Rafua, and I definitely want to thank you guys for joining today's session. It's called Legal Pitfalls You Need to Know Right Now. And here you are. So there we go. Please feel free, of course, to engage throughout. There is going to be a Q&A box right there below. If you guys have any questions throughout this session, just go ahead and write them out. They may be answered. If not, we will touch on them at the very end. And without further delay, we'd like to introduce you guys Silicon Hills stage. This is our virtual stage. And this stage is going to be sponsored by Coca-Cola. And we'd like to play for you guys a quick video.
We may be one of the world's most familiar companies, but we make more than our name suggests. We're an organic tea company, a premium juice company, a coconut water company. We've got drinks for long days, for birthdays, for turning over new leaves. And we make them for every moment in every corner of the country. We are the Coca-Cola Company, and we're proud to offer so much more.
Awesome. Thank you, Coca-Cola, for sponsoring this stage. We definitely couldn't do without you guys. And I'd like to introduce to you for today's session, our Vice President of Government Relations and Advocacy for the TRA, Kelsey Strufert.
Hey guys, thanks for joining us today. We've got a really awesome panel with three great distinguished guests. So without further ado, let me introduce those to you. First, we've got Jacob Monty. Jacob founded Monty Ramirez LLP to offer an integrated approach to dealing with Hispanic workforces. He's an expert in immigration, labor, and employment law. Thank you for being with us today, Jacob. We also have Talley Parker, who is a principal in the Dallas office of JacksonLewis PC. Mr. Parker is an expert in all things employment law and litigation. And then we also have Ethan Davis, who is an associate in the Dallas office of JacksonLewis PC. He also specializes in employment law. So we've really got a true panel of experts with us here today. And just so y'all know, these two law firms work hand in hand with TRA on issues that seem to come up almost daily and weekly. And so we greatly appreciate their partnership, and they're joining us today. So thank y'all.
Thank you very much.
So I know we've got a PowerPoint that I will turn on unless anyone has kind of opening remarks or anything before the PowerPoint. All right, without further ado, we'll go ahead and share that. All right, is that showing up on y'all's end? Oh, I should probably do the presentation.
Perfect. If you can go to the next slide. All right, thank you, Kelsey, and thank you for the introduction. Again, my name is Talley Parker with JacksonLewis. In the time that we have today, we really wanted to cover 5 big topics for you all. First of all, my colleague Ethan Davis is going to talk about preparing for the second wave that we've all been hearing about from the start of COVID. COVID, caught pretty much everybody flat-footed, right? And there were a lot of issues that came up that employers had never encountered. Now we've got a little bit of experience and understand what issues are going to come up should there be a second wave. So we just want to help you better get prepared for that should that arise. Hopefully it won't, but if it doesn't, you'll be prepared. Jacob's going to talk a little bit about the FFCRA. That's a law that was passed in response to the coronavirus, and Jacob actually presented with a webinar with us on that, I think back in April or May. We're going to revisit that because it's still in effect until the end of the year, and he's going to talk about the basics of that and the key issues you need to be aware of. He's also going to help you guys understand what you need to do in the event a COVID-19 arises or a case arises in the workplace. We hope it doesn't happen, but if it does, we want you to kind of have a playbook that you can roll out and know what steps you need to take. And then Ethan's going to talk about school because we're at the beginning of the new school year here. At least where I am, I'm up in Plano, Texas, up here in the Metroplex. Most schools are going to be remote at least for the next 3 or 4 weeks until after Labor Day. And then they'll evaluate whether to go back. And if so, is it 5 days a week? Is it a couple days a week? He's going to talk about how school coming back in session now, whether it's in person or remote, how that's going to affect your workplace. And then I'm going to close it out and talk a bit about the litigation and employment risks, the trends that we're starting to see already. We've been dealing with COVID now about 5 months. And so claims are starting to trickle in both state and federal courts. We'll talk a little bit about what we're seeing and what we expect to see on the horizon as we continue to deal with COVID and more litigation arises. So that's what we're going to cover today. And Jacob, why don't you get us started or Ethan rather, why don't you get us started by addressing the potential second wave?
Yeah, perfect. Well, thank you for the introduction, everyone. So as Talley noted, we are five months into this thing and there's no clear end in sight. And so I think at this point there is a continuation of the first wave, or it's a second wave, however you want to qualify and classify it. It's likely that COVID is going to be an impediment into your business operations for the foreseeable future. At least until, there's a vaccine and maybe the vaccine can get distributed, it doesn't look like short of that, business will fully resume and go back to normal, unfortunately. So everyone needs to be prepared for the second wave, for the continuation of the first wave, because, in short, I think that's going to be your reality for the next, foreseeable future. And so what's important to do is revisit your initial plan. How did you handle things in March when, the economy started shutting down, your restaurant started shutting down? What was your initial response to the COVID-19 pandemic? And look at what went well for you, what didn't go well, and use this time to evaluate how you can improve those operations, how you can improve your staffing, how you can improve your food ordering, how you can improve your customer service, your safety precautions, because this is going to be your new normal for at least the foreseeable future. So, you need to try to maximize your business efficiency, maximize everything you can, with the understanding and the implication that COVID-19 is going to be here to stay for a little bit. One of the things that's going to be really helpful and key for you is developing good communication practices with your employees. It's important for your employees to understand what your plan of action is, what your safety precautions are for them, for your customers, your food safety, your food handling. So the more you can communicate with your employees, the more that they feel comfortable working for you, that's a good thing. Another thing you're going to have to do is manage absenteeism. That's something that Jacob Monty's going to get into in a little bit, going over some of the options that you have at your disposal, some of the things, some of the laws that will protect the employees and the new leave laws, and he'll go over some of those things that you need to be aware of. But managing absenteeism, because quite frankly, whether it's for childcare, whether it's because someone has COVID, whether it's because someone's been exposed to someone who may have COVID, you're going to have employees who are going to miss time over the next couple of months. So that's unfortunately another reality that you all are going to have to be aware of. And so some of the new solutions that we'll talk about, considering whether furloughs or reductions in force are necessary, that's something you've all had to make those decisions up to this point, most likely, figure out how to handle staffing for the decreased volume of customers that you've had, whether because your business is closed, whether because dine-in is closed, you're at reduced capacity. Employees aren't going to be working the same hours right now that they used to when you guys are running full steam ahead. So you need to consider what options are best for you and how you can staff your restaurant so that you're making as much money as possible, your business is doing as well as possible, but also taking care of, the employees in a way that, they like working for you, they appreciate working for you, and that's going to make you look good going down the road. Months from now, years from now, employees and customers are going to remember, who handled this pandemic well, which restaurants, which companies, went above and beyond, really took care of their employees. So, it's important to kind of have, positive messaging for employees and taking care of your employees. And of course the bottom line is important, but it's important, it's also important how you handle, any reductions in force or furloughs that are necessary and the types of communications that you have with your employees to inform them gently of those type of decisions. Something you may want to consider is, leveraging a geographically diverse workforce, suppliers, expanding your products and service offerings. For example, if you have certain things that do much better in your takeout right now, it's not likely that your restaurant's going to be 100% dine-in, in the near future. Or even if it is, it's not likely that it's going to be as full just because of customer fear, customer apprehension. So if you have stuff that's doing really well in your takeout, now's the time to consider reshifting your business focus and thinking about, what's doing well during these times and understanding that these, this COVID environment is going to exist. It's going to linger for a little bit. So now's the time to maybe stock up on those, those supplies, those product offerings that are doing well. And then just taking care of your employee physical, mental, emotional health needs. Some people are scared to be in the workplace. Others aren't scared. Everyone's different. Everyone has a different mindset of, what the risk is to them, the risk is to their family, and just being cognizant, being a concerned employer, being concerned boss. It's important to make sure that you're taking care of your employees during this time, providing them the things that they need.
Great. Thanks, Ethan. Well, it seems like COVID's been here for forever. It's actually only been since March that we've had to deal with it. We've had to deal with the Families First Coronavirus Response Act that came onto the scene relatively quickly. That happened in April, and we're going to dive into that. Basically, what this is the paid leave requirements that apply pretty much to all employers. It's interesting. The only employers that don't have to comply with the paid leave component are employers with more than 500 employees. It's sort of counterintuitive that the large employers don't have to comply, but the rationale was the large employers already have leave policies, so they wanted to make this applicable to the smaller employees. But the two laws that we're going to discuss are the EFMLA, which gives up to 12 weeks of job protection for employees who lose their child care facilities. And this is really probably the more onerous of the leaves. The other leaves are 2-week leaves. This is a maximum of 12 weeks of leave, but it's paid at 66.7% of their normal rate. So it's not at the full rate, but it is a long period of time. The more common leave that I'm seeing being invoked day in and day out is the emergency paid leave, the sick leave for COVID. And this is essentially 2 weeks for full-time employees. This is what you're going to see on a more day in and day out basis. These laws went into effect at the beginning of April. They end in December of this year. Hopefully, we have a better handle on COVID by then. But if we don't, look for some sort of extension to happen on that front. The reason we're covering this, folks, is if you don't offer this leave and you're required to, and again, most employers are going to be required to, even if you're not required to, if you're a large employer. Most of the large employers that I represent are complying with the law. But if you don't, you can be subject to investigation by Department of Labor Wage and Hour Division. They are actually in charge of enforcing this provision of the law. So it's not just a law that is encouraged to comply with. You actually can get into trouble and face penalties by Department of Labor for not complying with this leave. Also, you can imagine the public relations nightmare if you are discovered to not be complying with the paid sick leave provision particularly. So let's look at these 6 reasons for paid leave, and this will kind of guide the 2 provisions of leave. The first 3 are basically the sick leave provisions. This is what entitles you to roughly the 2 weeks of paid leave. The 4th, 5th, and 6th provisions are implicated if you're going to care for someone that has COVID. And then the big one, and Ethan referred to it, is number 5, and that is, childcare. If childcare is lost or interrupted, you get this long period of leave, up to 12 weeks of paid leave. Again, it's paid at 66.7% of their rate, but this is the longer period of leave. And these are the categories of the leave. Let's go to the next slide and we'll dive into it some more. There is a small business exception, but this only applies to the leave for childcare. So don't think that, oh, I'm a small employer, I won't have to provide COVID leave. That's inaccurate. All employers, even tiny employers, have to provide COVID, the 2 weeks of paid sick leave if someone has COVID. So, there are some exceptions, but they don't apply to the restaurant industry. So healthcare providers don't have to provide COVID leave, but again, that doesn't apply to restaurants. So you have to comply with this. This chart kind of illustrates the different types of leave. Again, it's basically the 2 weeks of paid leave, and then this longer leave that's applicable if you lose childcare or lose, even school, could be implicated there. So learn the requirements, follow them. Not complying with this provision of the law could get you in trouble with Department of Labor, but more importantly, it could get you in trouble with the media, and it could create a public relations nightmare. I've had to help a few clients already deal with issues that have come up regarding media wanting to investigate allegations that a company was not offering paid sick leave, and you'd want to avoid that. The other thing to keep in mind is all of us are governed by our local health departments, and under the model food code in Texas, you have to have a policy to ensure that employees that are sick aren't working in the workplace. So that's another way how having paid COVID leave interacts with the health department, because now when your health department inspector comes by, he will ask you, hey, do you have your model sick leave policy to make sure sick employees aren't working at the restaurant? And that's when you want to maybe show them your COVID sick leave policy. But health departments are asking for evidence that you are following the CDC guidelines relating to COVID. So that's another important reason to learn these leave laws. Let's look at the next slides, please. All right. My employee was sick last month and took 2 weeks off. He's sick again this month. Do I have to pay him sick leave again? Here again, it's 2 weeks maximum. So you don't have to give him an additional 2 weeks of leave. Once the 2 weeks have been exhausted, you're not required to provide him any additional paid sick leave. However, under you as a restaurant, you're supposed to have a procedure, a policy to keep sick employees away from the workplace. So make sure that you do have a way of ensuring that employees that are sick, especially with COVID or another transmittable disease, are kept away from the workplace. This is something that you'll be asked about it. So bear that in mind. What documentation can I require from employees? The most important thing is don't ask an employee for a positive COVID test before letting him take leave. It's important that you get him away from the workplace as soon as possible. You can ask him for documentation regarding actual COVID tests afterwards, especially if you're going to apply for tax credits under the law. You're able to get tax credits for any leave you do provide, and you can request backup. But the important thing is don't ask for it before you let him go on leave. It's important to let him go immediately, let him take his 2 weeks, and then ask for the documentation. And now, as Talley mentioned, we're going to discuss what happens if you do have a positive test. And again, we're hoping no one has that, but I've been dealing with employers that have had to deal with this since really, since February. So we've come up with a guideline on what to do. First off, you're going to have to quarantine diagnosed employees. And this is pretty basic. If he tells you that he is positive, you need to remove him or her from the workplace, send him home. Now, this part's pretty easy. The next part is harder though. This is where you have to notify and isolate exposed coworkers. Now, one thing you should know is restaurants are considered critical infrastructure employers. So you don't have to quarantine everyone who is exposed to the positive employee. You only have to quarantine people that are symptomatic. And what's the rule? Essentially, we're looking at this. Anyone who worked within 6 feet for more than 15 minutes with the positive employee should be notified that they were exposed to a positive employee. And there's a 48-hour component. Within 48 hours of the person being in transmission mode. So essentially, you're looking at anyone who worked closer than 6 feet with the employee for more than 15 minutes. The next part's important. You have to clean and disinfect the workplace. You don't have to use an outside service, but it may be appropriate to use an outside service to clean and disinfect the workplace. We have clients that are doing both. Some of them are doing it internally. Some of them are using an outside service. Lastly, you have to notify your health department. This is not required, but it's recommended. We certainly recommend it, that if you have a positive person, you let the health department know. That way they don't hear about it from the local hospital and they can see that you're being proactive. And then lastly, you do need to figure out when the employee can return to work. Good news on that front. We have a clear-cut guidance now on when employees can return to work. And it's essentially 10 days after they were exposed, and as long as they are not showing fever or any other symptoms. And they have to be fever-free for 24 hours. So that's basically what to do if you do have a positive employee at the workplace. One question that comes up is, do I have to tell anyone else? Look, you have a duty to let employees that worked with the employee in a close proximity to know, but you don't have a duty to let anyone else know. Some companies are letting the media know. Some companies are putting it on their websites. That's not required. It may make sense for you to do that. I think there was a stigma initially. That stigma has dissipated. I think restaurants now are more and more restaurants have had to deal with it. So if you do decide to put a notice on your website, it won't cause a great deal of concern. Again, we do recommend that you work with your health department, letting them know if you have a positive employee. We've seen firsthand positive results of this. The health department is relieved and happy that you took the step to let them know. And we've also seen situations where the health department was upset at the restaurant because they didn't let them know. So it's my recommendation to let the health department know if you have a positive employee and you handle that. But if you follow this, you can certainly get employees back to work. And as I said earlier, after 10 days have passed, you can return them as long as they're fever-free for 24 hours and all other symptoms have improved. Remember, the 14-day rule does not apply to us because we're critical infrastructure workers, and they are not to be quarantined as long as they don't show symptoms. This is different if we were not a critical infrastructure industry, but because we're critical infrastructure, we are allowed to only quarantine people that are actually showing symptoms. But if you follow these rules, you'll be able to get employees back to work and avoid the issues that could arise if you don't follow the different protocols. Again, the way you address this is by complying with the leave laws and by having a plan to deal with a positive employee. Remember, the time to think about it is now before you have that positive employee. It could happen, it may happen, and take a look at these slides and consider what your plan will be if you do have a positive employee. And Ethan.
Yeah, so now we're going to talk a little bit about what happens if school doesn't resume. Yeah. So we're going to talk about what happens if I would characterize that right now. It's not what happens if full-time in-person classes don't resume. As Talley noted at the outset of this presentation, it's going to be weeks for their name, and then it's to be, it's going. Yes. Hello.
Ethan, your audio is really kind of strange on my end. I don't know if
everyone hear me.
Jacob, Talley, are y'all getting that weird
underground,
underwater sound?
A little slow.
I'm going to text Ethan and tell him to turn his video off. That might be eating up some of his bandwidth.
Great. Sorry, guys, bear with us. This is the fun of hosting a virtual
everyone
conference.
Hear me?
Yes, that sounded better.
Can people hear me now?
Yes.
Okay. Perfect. My apologies, everyone. I'm sorry about the technical difficulties. So what happens if school doesn't resume? And we're talking about in-person, full-time classes. Because right now it looks like it's going to be a lot of remote learning. It looks like it's going to be hybrid learning after that. Quite frankly, no one knows what school is going to look like better. It's possible that people can resume in class, a hybrid learning at best. And so it's important for you to be prepared for employees to be able to have more flexible schedules if possible, and just understand that childcare issues may arise. You may have little leeway, little notice of when these issues may come up. And so you don't want to make assumptions regarding an employee's ability to work just because an employee thinks that their kids are going to attend school full time in September. That very well might change. Are the arrangements that would allow the employee to continue working, teleworking, modified schedule, flexible hours, based on your operations, it's possible that you're able to change your schedule to allow someone who maybe a co-parent, another caregiver can watch the kid after school hours. The employee can come in for the night shift if they usually work the day. If the employee can't work, you can explore the leave options. We already talked about the FFCRA, expanded FMLA. There are state and local laws depending on where you are potentially. existing leaves for PTO, vacation. Your restaurants may have certain policies that you can follow and you'll need to follow, if one of the new laws doesn't apply to your situation. Can we go to the next slide, please? Perfect. And so caring for a son or daughter whose school or place of care is closed or childcare is unavailable for reasons related to COVID-19. That's one of the FMLA qualifying reasons that Jacob talked about as your own child, but it's important to know that include biological, that's also adopted, foster child, stepchild, legal ward. Also important to note that, if you've been
Hey, Ethan, we're having issues again.
Needs to have been employed for 30 days to be eligible for If you've just 15 days right away, learn this expanded, just know that. And this document flexible. Can you hear me?
It's pretty in and out.
You might want to try changing your audio over to a phone rather than the computer. I think that could be an issue.
Tally, do we maybe want to skip ahead to your slides and then maybe come back to Ethan's?
That's fine. That's fine.
Okay.
I'm a little hesitant to talk right now, though. I hope it doesn't happen to me on my end.
Sounds good so far.
All right. Well, let me know if you lose me. But yeah, so what I'm going to talk about, I'm primarily a litigator, and that means handling law.
Enter your meeting ID, followed by pound. You have not entered any numbers. Please re-enter your meeting
Hey,
ID.
Cindy, can you mute Ethan for right now? Oh, okay.
Okay, so sorry about that. But what I was going to talk about is just some of the litigation trends that we're seeing already. As I said, COVID, 5 months into it, and the type of lawsuits we think we're going to keep seeing as we move forward with this pandemic. Going to talk about a couple different claims here. Disability and leave of absence management, that's always an issue, frankly. Aside from retaliation claims, which I'll talk about, we're getting more and more FMLA and ADA claims than any other type of claims. I think those claims lead the type of discrimination claims that are filed with the EEOC now, disability discrimination. That's going to continue as we work through COVID, given that it is an illness. It's going to result in more of those types of claims. Talk about some discrimination issues, health and safety and workers' comp, those kind of go hand in hand. And then finally, I'll touch on a few wage and hour issues. Wage and hour are always important for the restaurant industry, of course, given how many non-exempt employees you have. So let's start with a couple of the disability and leave of absence management. The claim that we see the most often, frankly, is I'm disabled. I have this condition. And by the way, you should assume under the liberal Americans with Disabilities Amendments Act that everybody has some sort of disability. And the law basically says if you've got a disability, your employer has an obligation to provide you with a reasonable accommodation. Doesn't have to be any accommodation, but a reasonable one. Failure to accommodate claims have proliferated since this law was passed in 1995, going to continue to come out of this pandemic. And the claims that we're seeing is, hey, you number one, you failed to comply or to accommodate with respect to the FFCRA. So for those companies that are under 500 employees, you failed to comply with the law. You might have thought an exemption applied and it didn't. And I was supposed to get whether it was 80 hours of time of emergency sick leave, or I was supposed to get the 12 weeks of paid leave because I didn't have a child care and school wasn't open. You didn't comply. Those types of claims have already arisen and they're going to keep coming down the pike. that law in place at least until the end of the year. So as employers continue to kind of struggle with that and providing those paid sick leave benefits to employees, more and more claims will come up. Doesn't really imply for the restaurant industry. I guess it could, so I'll mention it. But as more and more companies have gone remote, like a lot of law firms like ours, where folks are primarily working remote, we're going to see that employees, as we return from COVID, are going to request as an accommodation to work from home. They're going to say, hey, I did it for 6 months or a year, however long this plays out, and I was able to work effectively, whereas you wouldn't have previously allowed me to work from home. Now you're going to need to. We've seen it can be a reasonable accommodation, and I can do my job effectively. Let me hit over and just because of time, talk about some of the employment discrimination claims, Kelsey. With respect to employment discrimination, we know that tons of companies, unfortunately, in the early days of COVID, had to immediately shift in terms of what their workforce looked like and go into doing layoffs and doing furloughs. And the claims that have come out so far from a discrimination standpoint on that is, hey, you let go of 5 people. All 5 of those people maybe were of one race, or they were of one gender, or they were of one age category. That's discrimination. That's one of the discrimination type of claims that has come out of COVID. Also, retaliation. As I said, retaliation is the claim we see the most. And there it could be, I took leave under the FFCRA. I needed to stay home because my kid's school was closed. I needed to stay home because I myself had COVID, and you took action against me for exercising my protected rights under the law. You retaliated against me. We're going to continue seeing lots and lots of retaliation claims. Next, Kelsey, going over to health and safety. I get a list of the lawsuits that are filed each day around the country, state and federal courts, and there are so many individual lawsuits, whether it's I was harmed or unfortunately wrongful death type lawsuits against employers. I've seen them against McDonald's recently, against Tyson's, against Walmart, where folks have passed away from COVID, and their estates or their family members are saying, hey, employer, you didn't take proper steps to create a safe work environment for my son, my spouse, who worked for you and who passed away contracting COVID in your work environment. Employees are going to be bringing claims directly to OSHA, the federal agency that is insured or ensures that employers provide a safe workplace for their employees, but then also individuals or their family members may be bringing claims in court going around the OSHA model and saying an employer was negligent, or an employer was grossly negligent, or an employer wrongful death. Again, that's the most extreme scenario, but we are seeing those claims. So health and safety, going to see a lot of those claims continue as we work through this pandemic. And then with workers' compensation, fortunately, in Texas, we have the absolute bar with workers' compensation that unless someone can show they suffered an on-the-job injury because the employer was grossly negligent, then their exclusive remedy is to go through the workers' compensation system. But you're going to see a lot of workers' comp claims. You're going to see employees claim that they contracted COVID on the job. Thus, it's an on-the-job illness or injury, resulting in their ability to file and collect workers' comp. You might also see, I haven't seen this yet, but I can envision an employee claiming maybe that they were injured on the job simply for trying to comply with steps that the employer has made employees take to provide a safe workplace. Maybe it's wearing masks, maybe it's wearing gloves, wearing shield, and somehow they've hurt themselves. Maybe they can't breathe properly with the mask on. Maybe wearing gloves has caused them to, something slipped. I don't know. But you can imagine that employees could harm themselves in any number of ways kind of in this new work environment, and that's going to bring about workers' comp claims. And then workers' compensation retaliation claims. We see lots of those where an employee suffers an on-the-job injury, files a claim for workers' comp, and then something happens to them, some sort of adverse employment action. And they, of course, try to link that adverse employment action to their workers' comp claim. Workers' comp retaliation claims, very, very common. In my view, they're really common because they're an easier claim to prove to a jury than to prove that someone discriminated against them because of their race, age, gender, disability. I think it's a lot easier for juries to buy off and to believe that this person got hurt, they weren't able to work, they filed a workers' comp claim, the employer was upset or frustrated, and so they exited them. And so we see lots of workers' comp claims. We're going to continue to see them as more and more are filed as a result of COVID. And then finally, wage and hour, there's more claims filed under the federal wage and hour law, the Fair Labor Standards Act, than any other federal employment discrimination law. That was the case before COVID. It's going to be the case after COVID. A couple of the ones that stand out to me here related to restaurants, the types of claims is employee misclassification. With respect to your exempt employees, that's normally your managers, could be your assistant managers. Maybe as a result of having to downsize your workforce, those individuals were performing jobs that exempt the hourly employees historically performed. That's natural. You'd expect that, but you can see that some of those individuals, if they ultimately are laid off or they suffer some adverse employment action, they may come after you, the employer, and say, I don't have a good discrimination claim. I don't have a retaliation claim, but I think I've got a wage and hour claim. I think I was misclassified because you had me performing duties that non-exempt employees should perform. I wasn't performing the types of duties that exempt employees perform. I have a wage and hour claim. I think you can see those arising as someone who operates restaurants. Also, for furloughing salaried employees, this is something to think about. We're past it right now, I hope. But if there is that second wave, just remember, if you do have to do layoffs, if you do have to furlough salaried employees, if they've worked any time at all during the middle of a work week, they have to be paid their salary for that entire work week. So if you're going to furlough or lay off, or if you're going to furlough salaried employees, it's best to do that maybe at the end of the work week where they've already performed all their work, since you're going to have to pay them for that entire week, regardless, because if they've performed any work. Those are just a flavor for some of the wage and hour claims. And if we've got Ethan back on the line, since we've got a couple more minutes, we might want to revisit the school issues. Ethan, are you there? If you're there, you're on mute. If not, Kelsey, I don't think we have him there.
Okay, and if it's all right with y'all, we'll go ahead and share these slides so that way people can still get the school information that way as well. And I know we had, Ariel, I know we had a couple of questions from our viewers that we wanted to get to. So let's jump in with those.
Awesome. Yeah. So let me start with the first question from our audience. Okay. So they say, how can we follow some of the disinfecting and notifications when it's taking up for a week to get results? The employee is not at work because they suspect they have COVID, but by the time we get a positive response, a week has already gone by.
Oh, Jacob, you're on mute.
Muted. Jacob, you're muted.
Here, I can unmute.
Great question. The issue is if the positive employee or potentially positive employee has been away from the workplace for more than 7 days, then there's no need to clean and disinfect. But so even if they were positive, there would be no need to clean and disinfect because they've been away from the workplace a long enough period that any infection would have already dissipated.
And I'll just add too, keep in mind, this goes back to the communication being so critical with your employees. You need to be screening employees every time they come in for work for symptoms. So having those kind of checks on the front end will also be critical in this instance.
Yes, that's a great point. And, you know, Talley we covered the workers' comp part. You know, I hope everyone has workers' comp. In Texas, a lot of employers don't. And, you know, we have non-subscribers. Non-subscribers have to be even more careful and have documentation that they have complied with the different CDC guidelines. Otherwise, they face a very real negligence case. And I'm defending a negligence case already that has arisen out of COVID against a non-subscriber. So bear in mind that non-subscribers have to take COVID even more seriously because they don't have that strong protection that workers' comp gives them.
Very good point. Very good point.
Yes. Thank you, guys. Thank you, Jacob. And we do have another question. So the question is the employer required to notify still laid off employees that you are unable to bring them back due to various economic related reasons? And is there a template available for this?
Well, I'll hop in here. I mean, I view there being a difference between being laid off and being furloughed. Furloughed means you're still employed by the organization, right? You're not performing any work during this time, but there's the expectation you will be recalled in the future. Laid off technically means you've been terminated. You can call it a layoff, you can call it whatever you want, but if you've been terminated, your employment has ended. If the company were to bring you back, the company would have to onboard you just as it would with any other brand new employee. So I think as a courtesy, it can't hurt to just reach out to those employees because they might be sitting around. They might be thinking they're going to be called back to work. I doubt they are, but they might be foregoing other opportunities, and it's best to go ahead and let them know. But there's nothing that legally require you to notify them that you don't intend to bring them back, because by laying them off, you've already terminated them. You've already ended the employment relationship.
Thank you.
All right, well, we're at 3:15, so I'm going to go ahead and thank all of our panelists. Thank you so much, Jacob, Talley, and Ethan, for being with us today. This was a really great and helpful panel, and thank you to all of our viewers and Coca-Cola for sponsoring the stage and letting this happen. So thank you all very much.
Yeah,
Thank
thank
you.
you guys for tuning in, and we'll see you guys later today and also throughout this week on the stage. Thanks, guys.
Bye.